sure that you understand the basics of immigration before I continue on to discuss the changes both last summer that President Obama instituted for, it's called deferred action, as well as the proposed legislation in the Senate. So if we go, what I have here is sort of our basic roadmap for today. I'm going to cover the basic types of immigration, so ways that you can come to the United States. I'm going to discuss lawful permanent residence, then the deferred action for childhood arrivals, which is the official name for what happened last summer. In immigration, we call it DACA, which doesn't sound very exciting, but that's what we say. And then SB 744, which is the proposed legislation that was put out by the Gang of Eight in the Senate. I think they had like a great name there, the Gang of Eight. Anyway, so what I have here is various types of immigration status. In the bottom, you'll notice that I've listed out ways that you can be undocumented, because that's not just one way either. So I'm going to just briefly go through those, and I'm going to try to be a little bit quick with this since I've already talked about this, so most of you already have a basic understanding. But if you get really confused, just raise your hand. So the first one I have is to be a naturalized citizen. And a naturalized citizen is virtually the same thing as a natural-born citizen. There's like a couple of minor things that are different. You can't run for president. But other than that, you are a citizen for all intents and purposes. You can vote. You can work for the federal government. So in order to become a citizen, a person generally has to be present in the United States as a lawful permanent resident for at least 3 to 5 years, and they have to pass various tests, such as things related to civics. They have a little history/civics exam they have to take. And a little side note that I always like to point out is I give this test in my class for individuals who are usually third-year law students, and not all of them pass. So it is a kind of a rigorous exam that they have to take. They're given the questions beforehand, but not told which questions that they'll have. So there's about 100 of them, and they're quite extensive. So in addition to that, they also have to have a working knowledge of English in order to get their citizenship. Then, of course, once they've passed all these tests, they take an oath to support the United States, uphold its laws, etc., and then they become citizens. An important thing to remember about becoming a citizen is not only do you have all these tests, but you have to pass pretty rigorous background checks. And if you've committed any type of serious criminal activity, you're barred from citizenship. And in immigration terms, serious criminal activity is not always what we consider serious criminal activity. Most lay people kind of think murder and things like that. But a lot of times the criminal activity that can bar you from becoming a citizen can be minor things related to fraud. Not that any crimes are minor, but sort of on the lower end of the scale. So that's the introduction to a naturalized citizen. The next one is lawful permanent residence, and that is what everybody knows as having a green card. It used to be green way back, I think maybe in the 70s. It hasn't been green for a long time, but we still call it the green card. So in order to get your green card, well, let's first talk about what it means to be a lawful permanent resident or to have your green card. So essentially, a person that's here on a green card is, for all intents and purposes, kind of here permanently. They're allowed to work and travel freely. They can work anywhere they want, as long as they get hired. They can travel internationally. They can leave. They don't have to worry about getting any type of visa to come back into the United States. That's what that green card is for. They don't get passports, though, and they're not allowed to vote. So there's some restrictions. It's not quite as being the same as being a citizen. The most important restriction, though, that I think is important is to note that even as a lawful permanent resident with a green card, you can still be deported from the United States, and that's if you commit a crime. And again, if we go back to what we were talking about with naturalization, the types of crimes that can get you deported, obviously the big ones, the serious ones, but something as minor as what the state defines as a misdemeanor. In Arkansas, a Class A misdemeanor is if you commit a certain type of crime that's considered a sort of minor crime, you can be sentenced for up to 365 days in prison. Well, federally, that's considered a felony. So you theoretically could commit a misdemeanor in Arkansas, and that could make you deportable from the United States. So another way you can lose your green card is if you leave the United States for over six months, because they assume that you're no longer interested in staying here. So the next one is temporary non-immigrants. Under this category, people come here as a temporary non-immigrant. Actually, if you can figure out how to go back, I don't know how that works because yeah. Just don't pay attention to the screen. So for temporary non-immigrants, you get a visa that allows you to come to the United States for a specific period of time for a specific purpose. The best example of this is somebody that comes here as a student. So students can come, they're admitted for the specific purpose of attending a specific school that they have to get admitted to before they come, and they can stay until they get their degree. Once they get their degree, they have to leave. Another example of this is tourists, and we'll cover a little bit more when I go through that later, but once they've either accomplished the purpose for which they came, such as school, or the time they were allowed to stay in the United States has ended. For a tourist, it's usually up to 6 months. Then if they stay in the United States, they become overstay. And I'll talk about that when I go over undocumented. But just keep in mind that that's what I'm referring to when I go there. So the same restrictions apply to these individuals as individuals that are here that have green cards. They can be deported if they commit certain acts. They can also be deported, obviously, if they violate the terms of their visa. So once they've graduated from school, if they don't leave, they can be deported. Once they've reached that 6 months as a tourist, if they don't leave, they can be deported. The next two actually are what sort of the focus of the talk tonight is going to be. The first one is PRUCOL, which is kind of awkward to say. It stands for present under the color of law. And this is technically what those individuals that the recipients of deferred action were, the individuals that President Obama created a system for last summer. So that's what is technically their term. What it means is that they're present, they're sort of lawfully present for a temporary period, but it doesn't give them a status. And any benefits that they have or any rights that they have are completely up to the president, in essence, the executive branch, who makes those decisions. So they're allowed to stay here. They're allowed to work here under certain circumstances. Not everybody is given that benefit, the ability to work. And they're obviously, if they commit certain crimes, they can be deportable as well. In addition, I think what's also important is they can actually be deported at any time for any reason, because most of these individuals don't have a status, like we were talking about. They're not in one of the top 3, so because of that, they're actually usually undocumented, so they can be deported at the discretion of the president. So lastly, we have the undocumented, and these are individuals that have no status. They can be deported as soon as they come into contact with either Immigration Service or local law enforcement, if the local law enforcement has an agreement with the federal government, which some of our local law enforcement agencies do. They can be put into removal proceedings. Now remember when I said earlier, this includes a lot of different types of people. Undocumented entry is what most people think of, people that cross the border without having a visa. That is a large percentage of individuals that are undocumented, but we also have a fairly high percentage of individuals that have overstayed their visa if they came in on a temporary visa, or they violated the terms of their visa, and that's what we refer to as overstays. So those tourists that stayed after their visa expired, they would be undocumented as well, but they would be in the subcategory of overstay. And in addition, anybody who's committed one of those crimes that make you deportable would be considered undocumented as well if it erased their status. Does anybody have any questions about those basic things? Okay, so that's actually a really good question. Do people who have green cards pay their Social Security taxes or pay Social Security? And the answer is yes, they do. Anybody that works under any of those statuses, if they work and they have work authorization, they pay Social Security. In addition, a lot of individuals who are undocumented and don't have technical permission to work still pay Social Security and various other taxes through what's called the ITIN number. And some people think it's odd that people who are here undocumented and don't technically have permission to work pay into these systems. But the reason they do is as we'll get into later, almost all forms of relief require you to pay your back taxes. And that legislation that I'm going to talk about, that's one of the requirements, is they have to, if they haven't been paying their taxes all along, they have to go back and figure out how much they would have owed each year and pay those. So a lot of people kind of anticipating something like this have been paying all along. So I would say probably about 60% of my clients who are undocumented have done so religiously every year. And so why don't I go ahead and go to the next slide now and talk about our current system, how it stands now. So how to become a lawful permanent resident, how to get your green card. Some people don't really understand you have to actually have a basis for getting your green card. You can't just say, I'm in the United States, I want to work, I want to get my green card. You must first have this basis, and it's based either on family or business. So that's what that first requirement, you have to be eligible for a visa. So the second one is a visa has to be available. Only a certain number of visas are issued each year. And the third one is that you have to show that you're desirable, or in immigration terms, we call it admissible to the United States. Okay, so if a person comes to my office, there are a couple things that I'm going to go through to determine if they're eligible. And the first thing I'm going to do is kind of talk to them about their work and talk to them about their family to see if they might even fall into one of those categories. And if you look at that handout that I gave you, there's a front and a back. The front side, or I guess the longer one, the longer side, I guess it's not a specific side. The longer one talks about the various work visa categories there are. I don't know if there are any more. I think you'll have to share. Does anybody at the table have one? Does anybody want to lend them a couple? Okay, thanks. So the long side is the work categories. The short side is the family categories. All right, you're getting some. Hopefully, yeah. So to be eligible for a work visa, let's just have my hypothetical client. They'd first have to have a U.S. company that's willing to sponsor them, and then that company has to show there's not a U.S. citizen that can perform the job. And there's actually a really long, detailed process for this, and it includes that company actually has to advertise that position in its area. And if a qualified U.S. citizen applies, then they can't then get a visa for a foreign national. If there's a qualified U.S. citizen in the United States that applies for that position, they get that position. So it's not just any company can sponsor. You have to actually go through this sort of rigorous process. So for family members, if you notice on that sheet, and for those that don't have, maybe share, it kind of goes through the list of individuals. It breaks it down by relationship, so you have parents, children, sisters, brothers, and then further by age and marital status. So if I have a child that's 4, it's going to be a different situation than if I have a child that's 24. And the reasoning behind that is sort of what we consider a nuclear family in immigration law. Obviously, a spouse is different than a sibling. Okay, so let's see. The first thing I'm going to do is determine, if they have a skill or if they're related to a U.S. citizen, and then we have to figure out if they have a visa, the second one, whether a visa is available. Most of the temporary categories that I talked about, and we'll kind of enumerate a little bit later, have limitless numbers of visas, but there's very strict limits for visas for permanent residents. So we limit the number of individuals that can come here and get a green card. And if we do the next slide, you can see what the line looks like. So I work mostly with family immigration and not business, so I can basically give you the idea about the business, and that's on that, like I said, the longer side of the handout that I give you. But this is what I work with most often. So for business applications, just a little bit of information about that. Applications are accepted essentially on a first-come, first-served basis per fiscal year. And for instance, there are 85,000 visas available in the H-1B category per year. And to give you an idea of how difficult it is to get it, for fiscal year 2014, they opened the application process on April 1st, and by April 5th, they'd already received 124,000 applications. So that's well above what they had available, and that was within 4 days. So they've already closed the process for that. So if you don't get it in within the first week, you're not getting it in. And how that works is if you're not selected that year, out of that 124,000, they're going to have a lottery. And whoever gets chosen gets their visa. Whoever doesn't get chosen, they have to reapply every year until they finally win the lottery, so to speak. So what about family? This is the family. I'm not going to go through each particular one, but I am going to kind of demonstrate what these, I would go over there, but I don't want to mess this up, but I want to talk about what this means. So the numbers to the left on the top, 1 is unmarried sons and daughters, 2, so basically that lists out the category. And if you see where the description kind of matches up with this strange looking chart here on the bottom, what that means is, so for the first category of unmarried sons and daughters of U.S. citizen, each year 23,400 visas are issued. Now, if we look down in our chart, you're going to see what's called a priority date. And that is the date of application that's being adjudicated today, or this month, actually. This is the current month's application. So if I give, the best way to do this is a hypothetical. Let's say I have a client who's a 23-year-old, and she's from Mexico. She just finished college in Mexico, and she wants to come to the United States because her mother just became a naturalized citizen. So the first thing we'd have to do is we'd have to determine what is her relationship to a U.S. citizen. Does anybody want to guess which category it would be? 1, exactly. Unmarried daughter of a U.S. citizen. She's not a minor, so she wouldn't be an immediate relative. She'd be the unmarried daughter of a U.S. citizen. So second, we'd have to figure out, so that's in our list. That's the first step. The second step is, when will the visa be issued? So we go down to our chart, and we look at the first category. And that first number right there, under all other areas, it says 8 March 06. What that means is that today, they're adjudicating applications that were submitted on March 8th, 2006, which was 7 years ago, which means that this individual would have to wait at least 7 years until her application would become current. That's for almost every country. Now, if you notice, we have 4 other countries, and that's because not only are these visas issued by category, they're also limited by country. So each country only gets a certain slice of that 23,000 visas that are issued. And obviously we have higher rates of immigration from different countries. And the 4 highest countries are China, India, Mexico, and the Philippines, and they have vastly different numbers. So any other country than China, India, Mexico, or Philippines, they would have to wait at least 7 years if they're in that first category. Our client's going to be from Mexico, and if you see, that date is August 1, 1993. So that's approximately a 20-year wait. And just so you know, this is one of the things that will be changing with the legislation. So, so that's, like I said, at least a 20-year wait. And that is all I have to say about the visas as they stand right now. I think probably most of your questions will be, how are we going to fix this? So we'll go ahead and go to the next slide, and then we'll get to that later. But before we do, I want to talk about how we deal with that third step, whether the person's desirable. So let's say our client waited her 20 years, and now she has a visa. She's eligible for it. It's become current, which is the terminology there. Now we have to demonstrate that she's desirable. We want her in this country. So there's a whole long, I think about 20-page list of all the things that you can't do to be able to come into the United States. But I put up here one of the sort of the most common ones that I see. So hold on a quick second. Let me switch here. CIMT is what we call a crime involving moral turpitude. And again, I'm going to refer back to what I said earlier. This is not major crimes. These are usually fairly minor crimes that are considered misdemeanors in states. One of the ones that I think is, there's 2 actually that I always talk about. The first in Arkansas is a hot check. If you write a hot check in Arkansas, that's considered a crime involving moral turpitude because it's considered a fraudulent act. So that would be a crime involving moral turpitude. So if you've ever written a hot check, you're not going to get your green card. The second one, it doesn't really apply here because we don't have public transportation, but when I lived in San Francisco and DC, this was also kind of a big one. If you jump a turnstile at, say, the subway, or if you sell a bus pass, you know, those little passes that you can use to transfer, those are crimes involving moral turpitude. So I'd say that just to sort of delineate that it's not major crimes that we're talking about here. Obviously, those fall under the umbrella of a crime involving moral turpitude, but we can also see that some pretty minor crimes are considered as well. Any controlled substance violation, so first-time possession of half a joint would be considered, and anything above that, obviously. So anything related to a controlled substance, any conviction or admission to using those things will prevent you from getting your green card. Multiple convictions, so even if they aren't a CIMT or crime involving moral turpitude, if you've been sentenced for at least 5 years in the aggregate. There are certain health-related grounds as well. If you have various types of communicable diseases, you could be prevented from coming. If you haven't had certain types of vaccines, they can prevent you from coming. If they think that you may become a public charge in the future, they can prevent you, and any immigration fraud. But the real kicker is the last one. You can't have entered the country unlawfully, nor can you have accrued unlawful presence in the United States, because if you have, you can't get your green card. So that means for all those individuals who entered unlawfully, or if they've been here for any amount of time without a status, they are barred from getting their green card. What they would have to do is leave the country, and then they would be subject to a 10-year bar before they could come back and get their green card. So if we look at our client, you know, they have the 20-year visa wait, and let's say they entered the country on a tourist visa and they overstayed. Once they leave the country, that 10-year bar kicks in, so that's an additional 10 years they'd have to wait. So now we've put it at about 30 years before that individual would be able to come to the United States. These, for the most part, that unlawful entry and unlawful presence in the United States contributed a lot to the backlog that we have and contributed a lot to the undocumented population that we have currently, because a lot of those individuals, like I said, aren't able to adjust their status. Okay, one more slide, and then we're going to get into the deferred action and the bill. So this one, I just wanted to kind of list, because it's going to be important later, to understand the type of temporary non-immigrants that we have in the country and the visas that are available. Again, there's probably about, I think there's about 20 different types of non-immigrant visas. But the examples are foreign diplomats, anybody that works with foreign governments or foreign agencies are allowed to come here. Tourists, people that come on temporary business. Now that's not so you can come in and work temporarily. Temporary business is like a business meeting. You already have a job and you're coming in to perform some action within the United States. There's one for media. And then student, the most popular one. So those are sort of examples. None of these explicitly give you permission to work in the United States. One exception is the student visa. If you're here and you can demonstrate a hardship in your home country, then you can get a work visa. A good example of that is, I've seen a lot of individuals from Greece. When they first came, their country was financially stable, and then within a few years of them coming, a lot of the assets they held in their home country were sort of depleted, and so then they needed to be able to work. So that is temporary non-immigrants. Okay, so next slide. Now I'm going to talk about deferred action, and this is what happened last summer. But before I do, any other questions about sort of the basics of immigration? Mm-hmm. What status do you have while you're waiting? You have no status, and they would be undocumented. But you can't get your green card if you've been undocumented. Exactly. Yeah, it's kind of a little catch-22. Any other questions? Did you have you're just holding your hand like that? Can you apply from outside the country? You can apply from outside the country. Yeah, that's what a lot of individuals do. But you would have to wait that entire 20 years outside of the country. You couldn't come in. The difficulty with applying outside of the country for a green card is once you apply, you demonstrate intent to want to come to this country permanently, so you would then be ineligible for any of those temporary visas. So if my mom lived here and was a citizen and she sponsored me and I had to wait 20 years, I wouldn't be able to come and visit her in the interim because I will have demonstrated that I want to come, and you have to have temporary intent to come on a temporary visa. So you wouldn't be able to use like a tourist visa. Yeah.
If a person came to you or to your organization for assistance and help,
Mm-hmm.
and they didn't qualify, or they stayed way too long, or whatever, do you all flag those people that they get pounced on?
No, there's not, and in fact, there's not a sort of an affirmative duty for anybody to do that. And even within our court system, unless they're in immigration court or criminal proceedings, they're not flagged for any reason. So.
But they could come to you and there would be the same attorney-client?
Yes, exactly.
Relationship.
Exactly.
As if they went and hired someone.
Exactly, yes, yeah. And is sort of a side note for that, that counts even if we don't end up representing them. If they come in for an intake, the attorney-client privileges attaches as soon as they open their mouth. So, yeah, it's a good question. Okay, so what happened last summer? The DREAM Act, I don't know if any of you guys have heard of that, but so the DREAM Act was being pushed for several years in Congress, and it was for individuals that sort of fell under this idea of they came when they were kids, their parents brought them, they've basically grew up in the United States, and they've now since graduated from high school or going to college, and people felt like this is a special set of individuals. This is a little bit different than the parents who brought them, for instance. And so it was a little bit more sympathetic of a group, and so various senators, Congress people in general, tried to pass this DREAM Act. And what it would have allowed is for sort of a path to citizenship for enumerated individuals that came to the country when they were kids, essentially. It never passed. They tried attaching it to different bills, and it got unattached, and it just never made it. It was too sort of it was a political hot button, basically. So what happened last summer was that President Obama didn't create a path to citizenship for these individuals, but what he did is he made it easier for them to stay in the United States. And that was within his power as the head of the executive branch, because the executive branch enforces immigration. So there's always been this thing called deferred action or prosecutorial discretion. And under that, an individual can choose not to prosecute somebody. So the way I like to compare it is if you're in the criminal system, a prosecutor can decide not to prosecute somebody for a crime if they don't think they have enough evidence, or if they have limited resources. A lot of time different localities will decide to say not prosecute hot check convictions because they don't have the money to do that. They would rather focus on people who were murdered or something like that, right? So you're allocating your resources. And essentially that's what happened last summer. The president said, we want to allocate our resources to get the people that are here undocumented that have committed crimes. So along with this deferred action, there was an internal memo that said, let's focus and let's double up our efforts on finding individuals who have committed serious crimes in the United States and work on deporting them. So one thing you have to remember is deportation isn't just a, hey, we want to deport somebody, you're out. It's actually a really long, drawn-out process. You have all the due process rights that any citizen or any person in the United States does. So they're allowed a hearing before an immigration judge, and that judge gets to determine if they're deportable and then gets to determine if they're eligible for any type of relief. Because there are so many individuals that are here undocumented that have been put in that system, it's about a 3-year wait to get a full hearing. So if we are putting everybody into that immigration court system, then all of a sudden it's going to become so backlogged that it takes 5, 6, 7 years to be able to deport somebody. So what the president said was, we don't want to deport kids that were brought here when they were 2. We want to deport the person who killed somebody, or we want to deport somebody who's a drug trafficker. So let's focus on those individuals first, and then create a system where we can sort of register and keep track of everybody else. And so that's what he did. If you look up here, you can see that what the requirements are and what the benefits. You have to have come before you were 16. You have to have been under the age of 31 on June 15th, 2012. That was the date that it was a couple of weeks before it was announced. And they have to have continuously resided since June 15th, 2007. So they have to have been here for at least 5 years as of last year, 6 years now. They can't have committed a significant misdemeanor or have 3 or more convictions in general. What significant misdemeanor means, we're not too sure. We know that it's at least one of those crimes involving moral turpitude, probably a little bit less, but it's determined on a case-by-case basis. And then they submit an application. It costs about $465. So what are the benefits? They're allowed to stay here for 2 years. And then after that 2-year period is up, they may be able to renew that if we haven't passed any type of legislation. They may be able to get state benefits such as driver's licenses, but just beware that not all states have allowed that to happen. They may be granted 2 years authorization to work. Not everybody is guaranteed authorization to work. They have to demonstrate a need. And have in-state tuition ? And this is a really important point. Several states have explicitly stated that if you are within this status, you can get in-state tuition to a university. Arkansas is not one of those states, so we still are not allowing individuals in deferred action status to get in-state tuition when they go to a public university. Just a little note for you guys to think about. A couple things to remember also, it's discretionary. It's determined on a case-by-case basis. There's not really an appeals process, so if you're denied, you can't really argue in a court of law that you were wrongfully denied. It can be withdrawn at any point. Remember, because it's headed up by the executive branch and it's sort of a discretionary form of relief, it can be withdrawn at any time. So even if they get 2 years work authorization, that doesn't mean they definitely have the right to stay for 2 years. Tomorrow, President Obama could say, hey, I don't like this anymore, I'm going to take it all away, and they would all lose their status. I don't think that's going to happen, just know that it could. And it doesn't erase anything. So all of those bars that I talked about and, unlawful status and unlawful presence and entering unlawfully, it doesn't erase the fact that those happened. So it doesn't create a path to citizenship. It doesn't create a way for them to get a green card. They still have to wait in the lines that we talked about, and then they still have to suffer through the bars if they were present unlawfully, which we know they were. So, any questions about that? Yeah. So that's actually a good question. They can get travel authorization. And since it's a fairly new thing and they're just being adjudicated now, we don't have a really good sense of sort of across the nation how that's playing out. So the first part is that for the most part, we're seeing that most people are being granted work authorization. You have to apply separately for travel authorization after you've already received it. So people are just now submitting those applications and getting results. The sense that the government has given is that work authorization may be given, but it's going to not just be a blanket, you can travel as much as you want. It would have to be for a specific purpose. And they're not just going to hand that out. You have to actually show some type of need, like you have an ill grandmother at home or an ill parent or something like that. So it's not just going to be so you can travel and go on vacation. Yeah.
Let's say you're 18 years old, you want to go to university, you've been here since you were 6, and your family is still here undocumented. Do you put them in jeopardy of being deported if you apply for this?
So that's a good question, and just to repeat that so everybody can hear, I'm sorry I forgot to do that for the other question. But so if you're 18, you want to go to university and you want to apply for this, but the rest of your family is undocumented, do you put them at risk by applying for this? That's a good question because at first we didn't know the answer. Now we do know the answer. The government has explicitly stated that none of the information on these applications will be used to initiate removal proceedings. So that's both for the individual and for the family. So if an individual applies and you find out that they're not eligible because the government determines that one of the misdemeanors that they committed was significant, then they most likely won't have removal proceedings initiated against them, or if they can't demonstrate, that was actually a bad example, because if they committed a crime that they considered as deportable, they probably would be put into removal proceedings. But if it's about presence or anything like that, they won't initiate deportation against them, and they won't use any of the information regardless against their families. So you're safe. What other questions? Yeah, in the back. Deferred action, yeah.
And you're 18 years old, you want to go to college. Can you get a student visa without going back to your native country?
Good question. So let's say you were brought here when you were 2, and you're about, let's change it up a little bit and say you're about to turn 18 and you want to go to university here. Could you get one of those temporary non-immigrant visas, a student visa, to come to the United States? If you leave before you're 17, theoretically, yes, you can, but you have to leave. You can't stay in the United States and get it. You have to actually leave the country and then apply for it. And then, of course, if you don't get it, you wouldn't be able to come back. So, but that's only if you leave before you're 18, and it's theoretically. My advice as an attorney is to never lie on a visa application, and I would hope if you've been here for 16 years, you wouldn't lie and say you hadn't been, and that you would reveal that on the visa application. The problem, once you reveal that, and if you reveal that your entire family is here and you have absolutely no assets and your family has no assets at home, remember we talked about for the temporary visas, you have to show that you have temporary intent. You can't have an intent to stay in the United States. The reason you most likely won't be given that student visa is because it's going to be really hard to show, well, I only intend to come here for a couple of years to go to school. If your entire family has been here, if you grew up here, it would be really hard to show that. So that's why that's one of the reasons why theoretically you could get a student visa, but likely you probably wouldn't.
Do you know anybody who's done that?
No. Yeah. The majority of the people that I encounter aren't willing to take the risk. They want to stay with their family, so they stay in the United States and sort of live under the shadows and take those risks of remaining in the United States undocumented. So, any other questions about this deferred action, what they've done? So basically, it's kind of a temporary fix. It's a Band-Aid for a system that, to deal with all the kids that are here that would have been eligible for the DREAM Act. So let's go to the next slide, and we can talk about what is now SB 744. I was saying earlier, it's 844 pages of legislative awesomeness. It's quite a read. I finally made it through all of it, but feel like I have to read it again just to make any sense of it. But there's some really good summaries out there if you're interested, and Sally's done a wonderful job of getting lots of different resources about that. So check out the website. I think, is that available to everybody? Right, it's great. It has wonderful resources, and I'll talk maybe a little bit about that at the end if I have some time. But so what did SB 744 propose? It's huge. It has a lot of different aspects. There are a lot of enforcement provisions, so beefing up the border fencing, border security, beefing up enforcement internally as well. What I'm going to talk about today, though, is sort of some of the major changes. And so there's 2 categories. We talked about permanent visas and we talked about temporary visas. So you can see these are the main changes. sorry. These are the main changes in the permanent visa category. First of all, it's erasing entirely the sibling category. So when we looked back at that list of family categories, you could petition for your brother or sisters if you're a United States citizen. That will no longer be available. They will no longer have visas for children over the age of 31, so I would not be able to petition for my beautiful daughter if she were over the age of 31, which is 31 years from now, so that's not an issue. It changes the number of allocations for employment. It actually increases the number of visas available for permanent employment. And it creates this merit-based visa, which is actually really interesting. So essentially, if you kind of look at it, they took a couple of categories of visas and mashed them into this. There used to be this thing, which I didn't talk about earlier, which was called the lottery. And specific numbers of visas were available for each country that didn't have a lot of immigration, so for a lot of European countries, and you would just submit your name, and they would draw your name out of a hat, and if you got it, you got a visa. So they did away with that, because they were like, that's not really what we should be focusing on right now. So they took the numbers for that, then they took the numbers for the sibling category, and they took some numbers from that family category with children over the age of 21 and created this merit-based visa. And under the merit-based visa, they look at a whole range of things and kind of it's a point-based system, essentially. And so they look at your education, your employment, the length of residence in the United States, family ties, and a couple of other things. So basically, they're creating a way to have sort of a whole picture visa, which makes a lot more sense, I think, to what our immigration system has grown to, or what the United States has grown to, versus back in the 50s when they created the lottery visa. And we didn't have a lot of immigration. They were trying to encourage immigration from various countries. We don't really need to encourage that so much. We have enough. Now we need to figure out how to allocate it well. And I think that this does a good job in doing that. In addition, another thing about that merit-based visa is it's tied to the unemployment rate in the United States. So this is what I think is most interesting about this entire bill, is that for the most part, a lot of the employment categories are tied to various economic indicators, including unemployment rate, and it also requires that certain reports be created that analyze the economic standing of the United States. So it's creating a flexible system that we can change as time goes without having to go through all of this again. We don't have to get all of Congress to agree to create more visas in a specific category. They're actually kind of creating a flexibility built in, which I think is really interesting and hopefully good. I'm going to go over the temporary visas. Some of the major changes here is that it increases the number of the current visas. It creates a program for lowered skilled workers. So remember before I talked about those temporary visas, there wasn't really a category to come here and work. Now there is. It's called the W visa. And if you remember, George W. Bush tried to push this very same visa. It was basically a 3-year temporary work visa that would allow you to come work for 3 years. You could renew it, I think, 2 to 3 times. So this is essentially the same thing. The numbers for those are tied again to unemployment rate and those various required studies that they have. In addition, one other thing they put in there is that individuals that come here for work have to be paid at a higher rate than U.S. citizens, the average U.S. citizen, which, you know, is supposed to, I guess, defer or kind of deter wanting to hire foreign nationals. So anyway, they're basically they're trying to tie it to the various economic things here in the United States. So major changes. I'm going to talk in a second about the path to citizenship that is created, and both for the general undocumented population and for those DREAM Act kids. But before I do that, questions? Okay. So what are we going to do about the 11.5 million people that are here undocumented? There is a path to citizenship, and if we go to the next slide, these are the basic requirements and the basic benefits that you'd get from it. It's called registered provisional status, so it's a registered provisional immigrant, RPI. This kind of sounds like RBI, but anyway. So they have to show they're a resident since December 31st, 2011. I'm going to explain that just a little bit. Usually in immigration provisions, when they change things and they make people eligible for something, they backdate it because they don't want a huge influx of people. So if they would have postdated it and said, you have to have been resident since, January 31st, 2013, or actually it doesn't make any sense, sorry. If they would have postdated it to the date that it was enacted, then you would see a lot of people crossing the border right now, like just saying like, oh, I want to get in under that. That's the theory anyway. So they always backdate things. All in all, by the time they become citizens, they're going to pay a total of $2,000 in fines. That's over and above the amount that they have to pay for their applications. They haven't issued the application costs, but typically a visa application for a green card will cost close to $2,000 as it stands, so I would imagine that that's probably around the cost that it would be for them. So fines plus an additional $2,000 to $3,000 for the applications. Criminal ineligibility, again, as we know, you have to show desirability to be able to come to the country, so you can't have committed certain types of crimes. Here it is any kind of felony or 3 misdemeanors. So again, they're creating a whole nother category of criminal things for us immigration lawyers to freak out about and try to figure out what it means. We don't quite know yet if that felony means those Class A misdemeanors in the United States. If so, that's actually going to put a lot of people out, because remember, a hot check is a felony as far as the federal government determines it based on the state definition. So that would probably cut out a lot of people. But that, I'm sure, will be worked a lot in the amendment process. They have to spend 10 years as a registered provisional immigrant. And during that time, they're subject to a lot of requirements. They have to pay all their back taxes. They have to work almost the entire time. They have to show that they had a steady work history during those 10 years. They have to learn civics, that civics exam that I talked about earlier. And they have to learn English, or show that they're attempting to learn English before they can then adjust to become a lawful permanent resident. Once they get lawful permanent residence, they have to wait another 3 years before they can apply to become a citizen. And that, the same things that I talked about to be able to apply for a citizenship at the beginning count towards these individuals. So what do they get? They get temporary residence. They can stay in the United States. They can work. They'll be able to travel freely. Drive, I put a question mark next to that because we're not too sure, again, how states are going to interpret that. Driver's licenses are state benefits. As under deferred action for the DREAM Act kids, not every state is allowing individuals to have driver's licenses. So I'm assuming that that will be put into the legislation, that certain state benefits should be available to them. Obviously, it would be very difficult if they couldn't drive and they could work. So hopefully that will get worked out. They aren't going to be eligible for any means-tested benefits, so nothing either federally or state. And they're also not eligible for any benefits under the Affordable Care Act as well. So the types of things that they would be eligible for are fairly limited. So that's the path to citizenship that the bill created for the majority of individuals that are here undocumented. It's a 10-year path. It could be potentially longer depending on the specific individual. It's pretty, there's a lot of restrictions on it, I think, and then obviously the money that they would have to pay in fines. And we'd have to do that as well. Any questions? Yeah. That's a good question. That's actually a really good question, because they created an entire a fund that would go towards, basically it's kind of recycling it. So all of the fine money and a lot of the application money is going to go into a fund that will then fund enforcement and border security, as well as adjudication of all the applications. So, yeah. I think a certain percentage of it might go to the government in general, but for the most part, it's kind of creating its own system. It's a really great question. and also at the very beginning of the bill. So clearly they thought that was the most important part. Yeah.
What is this hang up about, particularly under this new bill, about not letting people drive? Because they're gonna drive anyway. And if they drive unlicensed, then they may drive without insurance.
Yes, yeah. So, yeah, I mean, I think it also baffles me as well. You know, for a long time, the question was about driver's licenses. Why are we not allowing individuals to have driver's licenses, especially if they have some type of temporary status? And I don't know the answer to that. I think you're right that it creates a larger population of individuals who are unlicensed, therefore uninsured. And if they're going to drive, they're going to drive. But yeah, I wish I could give you the answer of the logic behind that. I've read some studies, some interesting studies that talk about, you know, there was a lot of sort of discussion about voter fraud during the last election, and the numbers are actually so minuscule that while that may be a fear, I don't know that that's necessarily a justified fear, if that makes sense. Once you look at the numbers, you see that the numbers are actually really, really low of individuals who try to vote that don't have citizenship. But it probably is the reason, or one of the reasons for it, but again, not so much justified. But that's one of the issues. So she said, so what happens if you're married, one of them stays at home with kids and one of them works? So how is that going to work? That's a big question. And it's one of the things that I've seen kind of floating around in a lot of the blogs is how are we going to deal with individuals who are stay-at-home parents? They shouldn't be excluded from getting their citizenship. So one of the answers is that you can apply as a derivative under this. So for a family, say me and my husband and my daughter, if we were all undocumented, one of us, if I applied for this registered provisional immigrant status, I would be able to get it, and they could apply as derivatives because they're immediate family relatives. Now, that would then mean that I would have to make enough money for my whole family to live above the poverty level to demonstrate that. But that's one of the ways that people think that we'll be able to get around that situation. Obviously, it'll have to be played out in the discussions in Congress. But that is a good point and something that people are really concerned about. Mm-hmm. Right, so that's also a good question. What happens to all those people that are waiting in line? So we saw those numbers. Somebody from Mexico who applied for their adult daughter, there's a 20-year wait. So what happens to all of those individuals who are already in a line? So those under this system, that merit-based visa that I talked about, for the first several years, all of those, there's sort of two categories for that, but all of the visas within that will be given to the people that are waiting in line already until they sort of get rid of the backlog, and then they'll kind of start over. So those individuals will still receive visas. And actually, a really good point is, you know, there's that 10-year line for individuals who are undocumented. They have to first get their RPI status, then they have to get their LPR status, and then they have to get their citizenship. Well, before they can adjust to get their lawful permanent resident status, every single one of the individuals who are already in line have to have received their visas first. So it's kind of, there are a lot of triggers within the bar. So before this RPI status can start being given out, certain border security things have to happen. Certain plans have to be put into place. And again, for this, everybody who's already in line has to have gotten their visa before anybody that's undocumented can get their visa. So that's a good question. And I sort of left that part out. I think I forgot to talk about it. I got so excited when I was talking about the categories under family. If you get married, you're considered an immediate relative. An immediate relative, you're immediately available for a visa. So there's two situations that you're talking about. He said, what happens if you get married? Can you adjust status here, or do you have to leave the country? If you entered on any type of visa at any point, you can adjust your status. I came in as a student, fell in love in college, decided to get married, I can adjust my status in the country immediately. If I entered undocumented and I go to college and I fall in love, I have to leave the country, and then I'm then barred for 10 years before I come back. So that's a good point. And yes, no. I'm going to just quickly, because we're right at 7, I want to go over the provisions for the DREAM Act kids. that are in this legislation, and then I can kind of take some questions, and I know that we're nearing 7, so I probably should stop, but I will be available for questions afterwards as well. So under the DREAM Act aspect of this, basically they have the same requirements, those base requirements as the registered provisional immigrants, such as paying your back taxes, learning civics, learning English, etc. Plus, they have to have entered before they turned 16. They have to have a high school diploma or a GED. And then they have to show that they have either a higher education degree, at least 2 years in a bachelor's program, or 4 years in the armed service. And what that gets them is the same thing, temporary residence. They can work, maybe drive, no means-tested benefits, no benefits under the Affordable Care Act, but they only have to spend 5 years in that registered provisional status, and then once they've reached that 5 years, they can immediately become a citizen. So it's sort of a shorter path to citizenship. It's a 5-year path rather than the 10-year path. So it's a little bit, obviously, more difficult to reach, and they do have those educational requirements, but then the payoff is pretty high. So, all right, I'll take questions until they kick me off the stage. Yes.
I assume no benefits under the Affordable Care Act means that we're assuming you never get sick.
Yes. So one of the slides, I think I might have it on the next slide. I was gonna, if I had enough time, which I don't, was gonna talk about some of the stuff. And this would apply to the same thing, is that essentially you can't be denied emergency medical care, but you don't get any of this other stuff. No public health programs, no WIC, no driver's license, no work, no loans, no legal aid, no in-state tuition, and in some states you don't even get admitted to universities if you're undocumented. Almost the same amount of stuff would apply if you're in the RPI status. So yeah, it's unfortunate because it's not, I mean, everybody knows that preventative health care is better than emergency services, but that's essentially all that they're going to be eligible for. A huge issue. And hopefully it's one of the issues, I think that, and I know that it's definitely an issue that people are going to push for amendment when it goes through. Because remember, this is sort of our base plan. And if you have strong feelings about any aspect of that, any aspect of the bill, you should definitely contact your Congress people and let them know, like, provide those stories. I mean, provide those anecdotal stories. Putting a face to individuals, I think, is probably one of the strongest things that you can do when you're trying to convince people. So a story like that would be perfect to say, we can't just let these people come here and work for us and then not provide benefits for them as well, at least to some degree, at least bare minimum of benefits. So contact your Congress people. League of Women Voters of Washington County has a wonderful website with lots of links. Very, very informative. It also has links to sort of like any bill related to immigration that's been introduced, which is great. It has the text of this. There's some good summaries that are out there. That's a great question. That was one of the big things that people noticed right off the bat, that same-sex couples were not included in this legislation. So it didn't recognize marriages or any civil unions or anything. So there would be nothing in that. So there's hope. I've actually heard a lot of chatter about that on a lot of blogs, that's going to be one of the first amendments that's proposed in the Senate, is to add that on there. So it's a good question. Yes. So 2 points. The first is under this registered, this provision that we're creating, you wouldn't be able to go on to welfare to get any type of benefits. As it stands now, if you have a green card, you can seek certain types of means-tested benefits, not all of them, but some of them you can. What happens, though, is in order to get your green card, a U.S. citizen has to sign a contract with the U.S. government that says that if the person with the green card ever accesses benefits, that U.S. citizen is then liable to the U.S. government for the amount of benefits received. So, yeah. I think I'm getting kicked off the stage.
No, you're going to be thanked for a wonderful presentation. Very, very enlightening. Mary Alice Saravini from the League of Women Voters has a few words for us now. And thank you so much, Elizabeth.
Just on behalf of the League of Women Voters, we wanted to give you a gift of our book from the League of Women Voters of Arkansas, Government in Arkansas. It sounds like some of your students could use it. And we also want to thank you, Phil, for including us in the program tonight for the library here at the church. So thank you very much. We certainly appreciate all your expertise.
Thank you for coming.
If anybody wants to contact your congressman, Mary Alice Serafini has the League of Women Voters voter guides with information, and it's also on our website.